Tonight's bold question: did prosecutors ever have a chance? After my interview, it was clear they thought they had problems with witnesses. Dr. Bao, who remembered nothing. The lead investigator who said he believed George Zimmerman. And the IT guy who contacted the defense team. And tonight, we learn even more as we take a look at more unseen parts of my sit-down interview with the prosecutors. Ryan Smith is standing by with our in-studio jury. What do they think about what prosecutors told me? We'll find out as they deliver a verdict by the end of the program on our bold question tonight. Did prosecutors ever have a chance? Our in-studio experts tonight for the After Dark prosecution, former prosecutor Tanya Miller and criminal defense attorney Eric Johnson. And for the After Dark defense in town tonight from the left coast, defense attorney John Manuelian. Also joining us from L.A., civil rights attorney who has some strong words for the prosecutors in this case, Gloria Allred. In New York, Double J, Joey Jackson with us. And he represented O.J. Simpson and Charlie Sheen. Criminal defense attorney Yale Galanter is here this evening. Tonight, you'll hear more from my interview with the prosecutors, parts of the interview we haven't shown you yet, and we begin with the prosecution acknowledging some of the problems with their case.
We're stuck with the evidence we have. We would like to.
Are you being nice right now?
Well, no, this is the truth. You know, we don't get to pick our witnesses. We've got to deal with what we've got, and we've got to do the best we can. We were left with inconsistent witnesses in terms of what actually happened and his story. And what we were trying to prove is that his story was false. And we have inconsistent witnesses. So we felt his lies were so blatant that it would be obvious to people that he's making up a story. We were dealt with certain facts that we couldn't deal with. We were dealt with certain witnesses that we had to deal with. So you do the best you can based on the facts.
You did the best you can based on the facts, but did the prosecutors ever have a chance? That's our bold question tonight, ladies and gentlemen, of our in-studio jury. So here is your job tonight. If you believe they did beyond a reasonable doubt, you're going to vote yes at the end of the show. If not, you're going to vote no. Quick and easy and simple, right? You understand? All right, so you heard what they said about their case, but did they ever really have a chance? Take a look at one of the jurors.
Did you take an initial vote to see where everybody was?
We did.
So where was everybody? How was that first vote?
We had 3 not guilties, 1 second-degree murder, and 2 manslaughters.
This was a tough case for prosecutors, but I sat down with those prosecutors and talked about all of it. We sat down for like an hour and a half almost, and all anybody's talking about is one word. Hour and a half interview, one word, but that's what I want to talk to you about initially. We do one word every night here on After Dark, so I want one word from our experts tonight about Prosecutor Angela Corey's one word that she used to describe George Zimmerman. That word, murderer. Tanya Miller, one word to describe that one word.
Heartfelt.
Eric Johnson.
Disingenuous.
John Manuelian.
Unprofessional.
Joey Jackson.
Wishful.
Gloria Allred, one word to describe Angela Corey's one word.
Outrageous.
Yale Galanter.
Disrespectful.
Ryan Smith, one word to describe that powerful one word.
Bold.
All right, I'm going to pick out one juror to give me one word to describe Angela Corey's one word. Juror number 5.
Juror number 5.
Passionate.
Passionate. Strong words, Vinny.
Strong word. We have to talk about this. Usually one word we go away, but this is too important of a word. I want to start with you, Gloria Allred. You said outrageous.
That's right, Vinny. That is a word that the prosecutor should not be speaking at this time. George Zimmerman was acquitted by a jury. The job of a prosecutor is to seek justice, not to win, and not to not accept the jury's decision. She should not be accusing him of a crime for which he has just been acquitted.
What do you guys think? Was it outrageous or is it legit? I mean, she charged him with murder, so she obviously thinks he's a murderer.
Absolutely. Look, she had been under fire ever since God knows when about the decision to charge this man with murder. She had gone through this entire trial while the defense was on the news every other day, accusing them of all kinds of outrageous things. And what everybody was criticizing her for was, why'd you charge this guy with murder when the evidence doesn't support it? I think she's saying when she says that, honestly and from the heart, look, I believed it when I charged him. I believe it today. And just because the jury said not guilty does not mean he's innocent. And we've heard defense attorneys, pundits all over TV saying exactly that same thing.
I think the word disingenuous applies because at no point during the trial did they put forth a theory that he was an actual murderer. They put forth more of a theory that he was a liar, but not a murderer.
I think millions of people disagree with that. Millions of people watch this trial and absolutely think that there was sufficient evidence to support that he's a murderer, which is why people are filling the streets right now.
However, those people were not on the jury. They were not selected to be on the jury, and obviously those are not the people who supported the decision right now. Her word as being a murderer does not take into consideration the numerous flaws and problems that they had.
So you're saying they never had a chance. Let me go to Yale Galanter. Yale, you're down in Florida. That's where you practice law. What do you think of this one word?
Listen, I think her comments and the other prosecutors' comments were disrespectful, unethical, and they didn't appreciate the work and effort that this jury put in. Listen, there's a set of rules. Everybody played by the set of rules. They lost. They're being sore losers. This case, as you know, Vinny, this case should have never been brought. For them to still call him a murderer and think they had a shot at this is just absurd.
Joey Jackson, how about from your perspective when you heard that one word?
You know what? I do think it's irresponsible. I think that you can't fan the flames, particularly with a case of this magnitude. I think she was being wishful, but her job was to turn those wishes into reality. Apparently, she didn't do it, and I think her job as a prosecutor is to respect the process, respect the system, and ultimately, you know, call for calm and peace, not still call him a murderer after they tried their case and were unsuccessful in doing so.
In her press conference, though, Joey, she did call for that calm and peace. And again, that's just one word from this interview. We've got a lot more to show you and to show our jury tonight. Parts of that interview that you have not seen yet, but you'll see it tonight.
Chris Serino, for instance, the lead investigator. Did he make an impression on you?
Chris Serino did. To me, he just was doing his job. He was doing his job the way he was doing his job, and he was going to tell the truth regardless of who asked him the questions.
So you found him to be credible?
I did. Very credible.
When he testified that he found George Zimmerman to be more or less and overall truthful, did that make an impression on you?
It did. It did. It made a big impression on me.
Why?
Because he deals with this all the time. He deals with, you know, murder, robberies. He's in it all the time. And I think he has a knack to pick out who's lying and who's not lying.
One of the jurors, the first juror actually to come forward and speak out as to what the jurors in this case thought. So, did the prosecutors ever have a chance? That's our bold question tonight. And Vinny Politan's over in the HLNTV.com evidence room.
Thanks, Ryan. Ladies and gentlemen of the jury, did prosecutors ever have a chance? Well, to evaluate that, you got to take a look at the forces against the prosecution. And most of these, let's see, looks like almost all of them are actually prosecution witnesses. You begin with the ME, Dr. Bao. Remember him? Well, I remember him, but he didn't remember doing the autopsy on Trayvon Martin and told the jury over and over again, I remember zero. Imagine that being your expert. Could you have a chance if that's your expert? Then the alleged whistleblower, the IT director who worked at the state attorney's office, who ends up sending files and giving information to the defense in this case without first going to his boss. Then the jury in the case. We've heard from one juror already who had a hard time finding credibility with the state's key witness, Rachel Gentel. And then there's the lead investigator, Chris Serino, the cop. This is the guy who first interviewed the defendant, the former defendant, George Zimmerman. He's the one who got on the stand and said, I believed George Zimmerman, sent that message to the jury. Well, that's something I talked to the prosecutors about. Take a listen. The detective, Serino, at trial, basically saying, I believe George Zimmerman.
You think he was telling the truth?
Yes. This guy, I believe him, he's innocent. I don't see police officers doing that. I mean, is there something else going on here?
Well, what Detective Serino should have said is, I can't make that determination because once I finish my investigation, the physical evidence has to be analyzed, and that had not been done.
You know, we don't get to pick our witnesses. We've got to deal with what we've got, and we've got to do the best we can.
But usually you're in a safe place when you've got a police officer on the stand, right?
Usually we're on the same team.
Wow. So not on the same team with your lead investigator in the case? I mean, that's just one of the many forces that were against this prosecution, Ryan. And it was a tough case to begin with, but when you've got your ME doesn't remember anything and your lead investigator isn't on the same team, how do you have a chance?
It's a tough one, right? Far cry from the Arias trial where Juan Martinez, Esteban Flores sat next to each other at that table every single day. This is very different. So I want to ask our jury a question, Vinny, because I remember the prosecutors telling you, hey, they had to come in this case late. They weren't there from the beginning. So, ladies and gentlemen of the jury, I want you to vote on this, yes or no. Would the outcome of this case have been different if these prosecutors were on it from day one? Yes or no? A lot of yeses, but a couple of no's. Okay, let me go to juror number 4 here. She's a lawyer, full disclosure. Why do you say no?
I say no because if you look at it from the beginning, the minimum job was done, so the minimum result was achieved.
So it wouldn't have been any different, no matter if they were there from the very beginning?
No.
All right, let me come over to juror number 12 over here. You said yes, right?
Yes.
Okay, so juror number 12, Devin, why do you say yes?
I say yes because I believe if they had the case in the beginning, that they would have pretty much, if they had the case in the beginning,
it would have been done differently, maybe.
Yes, because of they're not going off the defendant's story; they're going on their own story.
That's an interesting point there. Now I want to come over to our juror number 9. She actually used to work for the public defender's office, right?
Yes.
And so you've got some experience with this. You say yes.
Yeah, I think that every lawyer works a case very differently, and I think that when you start a case, you want to work right alongside your investigators and police officers, and they didn't get the chance to do that.
You want that opportunity from day one. Maybe that affected the outcome of this case. We'll never know, right? Unless more jurors speak, we'll have to see. But you know what? We're going to hear more from the prosecution coming up.
I'm not at all being critical, but I want to point out a couple of things that are worthy of pointing out. Number 1, you have to pick your theory. Number 2, you have to prep your witnesses on the issue of theory. Is it second-degree murder and hate? Is it manslaughter and negligence? Or is it felony murder and child abuse? Pick a theory, stick to it. On the issue of prepping your witnesses, your lead doctor and your expert saying, I have zero, I have no knowledge, I don't know, and your detective siding with the defendant, it's not a recipe for prosecutorial success.
I'm going to read a quote from Mark O'Mara.
Well, I think that the things would have been different if George Zimmerman was black for this reason. He never would have been charged with a crime.
Ridiculous comment.
We charge people in this jurisdiction routinely, black or white, male or female. Aged is not relevant. It's the facts and the law without regard. We staff murder cases, Vinny, where we don't even know the race of either one until we're done with the staffing. That claim is preposterous.
Do you feel that George Zimmerman racially profiled Trayvon Martin? Do you think race played a role in his decision, his view of Trayvon Martin as suspicious?
I don't think he did. I think just circumstances caused George to think that he might be a robber.
So you don't believe race played a role in this case?
I don't think it did. I think if there was another person, Spanish, white, Asian, if they came in the same situation where Trayvon was, I think George would have reacted the exact same way.
All right, did the prosecutors ever have a chance? As we listen to what the jurors said and what prosecutors are telling me, we'll hear more of that interview coming up. Race Race. There, I said it. Oh, my goodness. Oh. Well, here's... the juror said race had nothing to do with George Zimmerman's interest or, finding Trayvon Martin suspicious. It was black teenagers who broke into that home invasion. It was the black teenagers who lived near the gate and the back gate that George Zimmerman kept talking about in the phone calls. It was black teenagers that George Zimmerman had called on before. It was a black teenager 3 weeks before the night he shot Trayvon Martin that was standing in the spot on Frank Taffy's front lawn where Trayvon Martin was standing. But race had nothing to do with it.
Right. And I think that that is part of the problem for the prosecution. They had a jury who did not see the racial elephant in the room in this case.
Who would see that?
They did not. I think African-American jurors.
Everybody would see it, but that goes to the fact of the jury selection. The prosecution played a role in the jury selection also. They allowed all of these people who...
No, two of them they wanted off. Yeah. Two of the white ladies they wanted kicked off, but the judge put them back on because they felt that they were being dismissed because they were white and they were ladies.
Prosecution never made this a racial case. They said there was racial undertones, but he was profiled. Trayvon Martin was profiled as a criminal, not as a black criminal, but as a criminal.
So what did the criminals who've been in his neighborhood look like?
Yeah.
Can you describe?
That was never brought.
Well, they couldn't bring it. Remember, they couldn't bring in the words racial profiling.
They couldn't bring the words racial profiling.
So they kept trying, it seems like, to kind of put that out there, but they were limited in what they could do.
I mean, can you describe for me who the criminals were that George Zimmerman was worried about in his neighborhood that were doing all these burglaries that he was talking about?
They were all young black men.
Right.
Look, even if they were to show that this was a race-based crime, they would open a Pandora's box. Then O'Mara and Don West would be able to bring out all the other things to rehabilitate his character, to show that it wasn't race-based. The fact that he took an African-American girl to the prom, the fact that he mentored 2 girls, it would open up Pandora's box. That's why the judge limited this to just profiling and not racial profiling.
Well, I think that the limiting to just profiling and not racial profiling is taking out the big elephant that's in the room. Almost all of America.
And without that, did prosecutors ever have a chance? That's our bold question. Our jury will answer it by the end of the program. We've got a lot more to show you. More of my interview with the prosecutors, my sit-down. We didn't show you everything last night. We saved some for tonight.
This wasn't a case about race. It was a case about evidence and credibility. Anytime the lead detective gets on the stand and says that the defendant is truthful and credible, and the prosecution gets up and objects, that sends a clear signal to this jury that the prosecution's case is in trouble.
Do you think Trayvon Martin threw the first punch?
I think he did.
What makes you think that?
Because of the evidence of on the tee, on the sidewalk, where George says he was punched. There was evidence of his flashlight and keys there. There's always something in the back saying, is it right? Is it consistent? But with all the evidence of the phone calls and all the witnesses that he saw, I think George was pretty consistent in told the truth.
And what we attempted to do as best we could is to prove that his story was false. Therefore, why would he be lying about something? Something minor like trying to get an address. I mean, I thought that was blatantly, obviously a lie. But we felt his lies were so blatant that it would be obvious to people that he's making up a story.
And those lies were put in front of the jury, one after the other, after the other.
So you see where the prosecution team is coming from, but the bold question, did the prosecutors ever have a chance? We've got our in-studio jury out here at our recreated shooting scene, and Vinnie Politan with our lawyers, ready to give some theories.
Well, and I want to point out to everyone what the juror was talking about, where the keys and the flashlight over here were dropped closer to the tee, and then the scene moves down this way, and she felt that that was very consistent because the other flashlight is here. Trayvon Martin ends up down here, that it was consistent with his story. So I'm wondering, lawyers, is there anything here at this scene or any of the evidence at all, whether it's the photos of George Zimmerman, chance because of the evidence at the scene, the way it was treated?
Absolutely not. The strength in the prosecution's case were the inconsistent statements that George Zimmerman made. The fact that his keys were found right here does not necessarily mean that George Zimmerman was struck by Trayvon Martin in the way that he said he was struck. These keys could have dropped in the altercation. We know that there was an altercation. The issue with this verdict is that the jurors just believed George Zimmerman. There was something about his narrative that appealed to them, something about what he told them happened that night, that Trayvon Martin somehow was responsible for his own death, that just convinced them that
and the bigger issue, this points out the flaws in the prosecution's case, because if you go back to the interview, she portrayed George Zimmerman as a person who stalked Trayvon, as a person who chased after him and started the fight. Nothing in the state's recitation of the facts would make it seem that that was their theory of the case. As Joey Jackson said, you have to have a theory in the case, and you have to promote it every step of the way with every witness.
The prosecution said that George Zimmerman got out of his car in pursuit of Trayvon Martin. Rachel Gentile testified that Trayvon Martin was trying to get away.
However,
they absolutely introduced evidence that there was a
the prosecution stopped
case.
as it relates to pursuit during the 4-minute period. The unexplained time of the 4-minute period, the prosecution did not go further to say that George Zimmerman continued to try to pursue Trayvon. They left that for the defense to give their own personal
I want to jump in on the injuries. With these injuries and this photo, did prosecutors ever have a chance, John?
No, and that's what I wanted to get to. That's what the important evidence is. We have evidence here that George Martin was hit on the right side of his nose and has got a bloody lip. And over here, if you take a look, you've got the injuries to the back of his head. If you listen to the testimony, Trayvon was about here, and according to George, his body fell right about here, and his head was slamming right about here. So that is what the defense was contending, that that was the weapon that was being used. And that's what the jury knows, and that's all the jury knows. What happened right here is a little ambiguous, but what happened right here is not.
That is absolutely ridiculous. When they cleaned this up, there was a scratch this big on George Zimmerman's head. That is absolutely inconsistent with what he said about the incident that night. There is no way that he could have gotten these insignificant injuries from having his head bashed into the cement. Again, the problem with this case was that the jury was predisposed to believe George Zimmerman's statement.
The prosecution didn't prove beyond a reasonable doubt that that didn't happen, and that was what the problem with the prosecution's case was.
The fact is, focusing on the injuries misses the main point. It doesn't matter that he had injuries. The issue is who started the fight. No one said that just because you start a fight does not mean that you can't sustain injuries in that fight. The fact that he may have been losing the fight does not preclude his liability if he was the initial aggressor who started the fight.
There's zero evidence to that.
However, that is the entire state's theory of the case, that he was the initial aggressor. So that is what they need to put forth every single time.
With hard evidence, and there was no hard evidence in this case.
But there was no hard evidence that he was not the aggressor other than his testimony, which they allowed in through his statements and did not force him to get on the trial.
We've got the arguments. Our jury has a lot of questions, and we got a lot more to hear from the prosecutors.
It's upsetting to me that in the Twitter world, many people are suggesting that this jury decided this case based on race. One of the jurors has been interviewed, and she explained the reasons for her decision and the decision of the jury, and the reasons she alleges were based on evidence. And she explained what that evidence was. The jury are the finders of fact. They gave weight to George Zimmerman's testimony and also to the testimony of other witnesses. Accept the jury's verdict. Don't say that it's racial if, in fact, the jurors gave a reason for their decision based on the evidence.
We have the best judicial system in the world. We are the envy of the world because we afford people due process. There are many people out there who don't like the verdict. The reality is that we may be pained and we may be hurt by the verdict, but at the end of the day, it's about having your day in court and having the prosecution establish his case and the defense defend theirs. The jury concluded what they concluded. We accept it, we live with it, and our democracy endures.
Will George carry a gun now?
I don't know. You know, I heard from Pierce Morgan actually last night that his gun was returned to him, or that at least he's eligible to have it returned to him. I don't know that he'll carry a gun. I would think that he has more reason to now than before, because there are so many more people who want him dead and that know that he's free, but at the same time he can move about a little bit more than he did before.
George Zimmerman carrying a gun again.
I'm a firm believer in the Second Amendment and the right to bear arms. I leave up to others to make comments about whether he should.
Do you think he'll be more dangerous or less dangerous after this verdict, George Zimmerman?
I don't know what to say, Vinny. I am an amazing advocate for the Second Amendment. I truly believe in the right to bear arms. We all do. We're all law enforcement. We all carry. We believe in that right for people. With that right comes great responsibility. We believe that George Zimmerman crossed the boundary when he pulled that gun and used it to kill Trayvon Martin.
Wow, that's why I said bold when you talk about the prosecution. And by the way, the bold question, did the prosecutors ever have a chance? Here we are at our recreated shooting scene, and this jury was writing down so many questions. They have a lot of them. Let's get right to it. Lauren, juror number 5.
I had a thought. So much was made of this 4-minute gap. But when we're driving and we think someone's following us, what is the first thing? We don't go home. We drive around. He also had his younger stepbrother at the house. Couldn't that not have been a reasonable thing to be put in the jurors as along with the theories?
Absolutely.
Exactly.
And that's what the prosecutor argued. The prosecutor argued that in closing argument. And it's interesting that this jury held against Trayvon, at least this particular juror, because we haven't heard from all of them, held against Trayvon Martin that he didn't run home, but at the same time gave George Zimmerman the benefit of not having to retreat. So I thought that was very interesting, and that's a question really maybe only the jury can answer.
What's interesting there in what you say, Tanya, is that Trayvon Martin had to run home, but George Zimmerman didn't have to get back in the car.
Right.
Right. Interesting point. Juror number 4.
Now, Tanya, you said something appealed to the jury. Do you have any thoughts on what may have appealed to the jury, that they believed everything that Zimmerman stated?
Well, this is an interesting question, and I think this is why you're seeing all of this dialogue going on now all across the country about the role that race plays in the way that we perceive things. It's not necessary that the jurors actually hold racial bias against Trayvon Martin, but were they more likely to view Trayvon Martin as one of those thugs that the neighbor described breaking into their house, and George Zimmerman not as a predator who pursued an unarmed child with a loaded handgun, but someone whose heart was in the right place and was actually trying to do the right thing. I think that's something we're going to be talking about for a while.
All right, let me get my juror number 11 back there on Janine.
Hi, Rain. I wanted to know, could you guys explain to me, I still don't understand to this day how Trayvon ended up beginning here with the escalation to where his body ended up. I still, even with the experts and George's statements, don't understand how he ended up there.
Well, basically, there was a confrontation. The confrontation may have started right here near this piece of evidence and ended up over there. We don't know whether there was punching, fighting, kicking, or anything else that was going on.
Here's what I want to ask you, John, because George Zimmerman basically says he gets punched in the nose, goes down to the ground, and he gets mounted and gets his head bashed, yet there's all this movement. I mean, if it's like one punch and George Zimmerman's on the ground, how do they start here and end up down there?
I got a better question for you. If that happened, how come their clothes aren't completely drenched? It was raining that night, and the only thing that was wet was Trayvon's knees and George's back. If they were rolling around, why wasn't George wet, and why wasn't Trayvon more wet?
Again, these are questions that only George Zimmerman can answer. And I think what you saw the prosecution doing by introducing all of these statements, he was interviewed or spoke about this incident more than 6 times, yet the story doesn't make sense. There were all of these gaps, all of these holes. We still don't have a clear picture of what happened. And what the prosecutor was trying to do by introducing those statements is show the jury, look, one person is dead. He can't tell you what happened. The one who's alive is lying to you. And the conclusion you can draw from that is that he's guilty.
However, the issue is, the one thing that he didn't lie about is that he said Trayvon hit him first in all of his 6 stories. At no point did he believe.
All right, so with that, did the prosecutors ever have a chance? We're going to hear more from them.
All criminal cases are about 2 things, the facts and the law. Here the prosecution didn't offer any facts to rebut the presumption of reasonable doubt. The law said they had to do that. They had to convince this jury that it was not self-defense. They didn't do that, and that's why George Zimmerman was acquitted.
So the question is, was the state trying to withhold evidence that could help the defense, or was Cryboss disgruntled and seeking evidence against his bosses? What was going on here? And did prosecutors even ever have a chance in this case with their own IT director going to the defense and trying to help the defense out? What?
I'm just trying to put it in a company perspective, right? Because I remember when this happened, I'm in Sanford, and everybody's saying, what a mistake by the prosecutors. Why are they doing this? Imagine you're in a company, and you're doing a presentation. It's a big one, and you find out a guy works for your company who gave information to the competition, and you told him not to do any of that. You would fire him on the spot. I mean, you wouldn't even give it a second thought. But here, the prosecution got hit hard in the press for doing such a thing, and I think that's kind of maybe a little bit of a double standard there.
And do you think that this impacts the case, though, when you've got people who are working within your office who are trying to help the other side?
I think that kind of shows how snake-bitten and unusual this case was for whatever reason from the very beginning. We see all of these very bizarre things happening, from the defendant not being arrested the night that Trayvon was murdered, to the IT director coming in and testifying against the prosecution, to the lead detective coming into court and saying that he believed the defendant. So it's bizarre. The timing seemed a little bit odd.
It reflects an overall mismanagement of the entire case. It would seem that this gentleman, if they did have this information that they thought may have been detrimental to their case, it would have been best for them to analyze it and figure out a way to properly present it to the jury rather than not providing it to the defense and creating this situation where the IT director...
Well, the bottom line is they did say in the interview that I had that they did provide it to him. It's just that they didn't have the computer ability to open it up, and when they finally did, both sides, because it was a secret file, they gave it to him.
And Vinny, that happens all the time. As a criminal defense attorney, I can't tell you how frustrating it is to get volumes and volumes of CDs and DVDs with special programs that you need from the prosecutor's office to open up things, and you can't open it up. So I completely understand what the defense went through in this case.
All right, Ryan's with our jury.
Yeah, so with all of that, did the prosecutors ever have a chance? That's the bold question that's before you, ladies and gentlemen. So it's time to start your deliberations.
A hook to hang your hat on. A hook to hang your hat on. Ultimately, what you need to do as a prosecutor or as a defense is give the jury something to fight about. Give them something to argue about on your behalf. Not it may be this, it could be that, but if you're the prosecutor, it is this, it is that. That wasn't done. That equivocation leads to reasonable doubt.
Our jury deliberating our bold question tonight. Did prosecutors ever have a chance? Here's what folks are saying at home. 23% of you believe prosecutors had a chance, but 77% saying no, they had no chance. Now, time for a mystery reveal. Thank you, sir. Let's take a look at what's inside my mystery box tonight. Are we ready? Take a look, ladies and gentlemen. Oh, who's that? That's Jodi Arias. Guess who was back in court today? Take a look at Jodi Arias in the courtroom today. How is she looking? She's got her hair up in a bun, wearing the stripes, Ryan. You know, she looks a little bit... A lot of people are talking about that she may look like Miss Casey Anthony.
I knew you were going to say that.
Look at that, with the bun. What do you think? Yeah, I'm telling you, I'm starting to confuse the two.
Where are the bangs?
Yeah.
Casey doesn't have the bangs.
That's true.
Come on.
The only difference is that one's convicted and one was found not guilty. By the way, Jodi Arias, the latest in that case, the judge wants to do it late September. What do you think? You think it'll get done late September?
Is that September of 2014?
No, this year. Late September.
Yeah.
Wants to get the juries to do the penalty phase of the trial.
It's possible.
I think it'll eventually get done. I know the defense wanted to put it off till January, so I think September was a compromise by the...
But if she's found guilty and she's locked up, what's the rush? Is there a rush?
That's what I'm saying.
But the prosecutor wants to get it done.
Well, it cools down. I mean, the whole thing cools down, and prosecution doesn't want that. And I think the defense wants to do that because they want to bring witnesses. Remember, Vinny, they didn't bring the mom. Nobody testified during the death penalty phase the first time. So the continuance is based on getting those people to deflect the death penalty.
Here's the problem, though, John. How do you explain this case to the new jury? What do? You sit them down in a room and show them 3 months of testimony? Yeah. Or do you give them cliff notes? How are they going to do that and get them up to speed?
I think you just show them how brutal the murder was, right? You show them the pictures, and you show them the blood, and you show them the scene, and they'll get an idea, because you just want them to hate.
And the defense is going to be cool with that?
Well, They have their chance for cross-examination. Hey, we got a verdict.
There you go. We got a verdict. Ladies and gentlemen, you have a verdict on the bold question. Did prosecutors ever have a chance? Let's go one by one. Juror number 1. No. Juror number 2. No. Juror number 3. Yes. Juror number 4. No. Juror number 5. No. Juror number 6. No. Juror number 7. No. Juror number 8. No. Juror number 9. No. Juror number 10. No. Juror number 11. Yes. Juror number 12. Yes. All right, so juror number 3 doesn't feel lonely, although she was getting a little lonely over here. Why do you say yes?
I just feel like they had the case that was handed to them, and maybe they just didn't do a good job, and I think they were sore losers.
Sore losers. All right. Let me get to my no, though.
I do think no, in the long run, they really didn't have a shot. I think on the first day, it was very poor taste to open with a joke, and that was where he put his foot in his mouth and lost the whole thing.
Do you think it would have been different? Prosecutors, they sat up here and they said, we weren't involved from the very beginning. We talked about this earlier.
I still don't think that it would have made a difference in the long run had they been involved in from the beginning or not.
All right, let me go back here. Some of my no's. Well, let me go to a yes first.
I think they just pretty much got the leftover evidence. If they were there from the beginning, they would have seen the whole picture. But since they were, got in the middle of it, they kind of got all leftovers. What was already done.
Okay, got time for one more. Let me come on over here. Carl, you say no.
No, the way they walked into it, the way the police handled it from the beginning, like not even making an arrest, not really collecting evidence. There was just too many holes from the beginning. And,
All right.
and they never really brought it together with what they had.
All right, Vinny, a lot of our jurors feeling like they were behind the 8 ball from the very beginning.
And I think a lot had to do with not being there from the beginning. And here's where I see the difference, okay? Because I spoke to the prosecutors, and they said they wouldn't have made an arrest for at least 30 days. But what they would have done was brought the parents in and explained to them the process, explained to them that it's a good thing that they didn't arrest them because they're collecting more evidence, and you wouldn't have had the police going in one direction